Um, so welcome everyone. This is our presentation on it is time to rewrite your governing documents. We're going to be going through many different aspects of the restatement and/or amendment process for your governing documents and the various aspects involved in doing that. And let's do introductions. My name is Brian Moreno. I'm one of the associates with the firm, and this is Cyrus Koochek. Why don't you introduce yourself, Cyrus?
Hi, everybody. My name is Cyrus Koochek, another associate at Swettles and Gottlieb, and I oversee our firm's amendment and restatement program.
Okay, great. Yeah, so I think there are many different aspects to the restatement and/or amendment process, and there's many benefits, many things that you know pluses for associations when they're considering whether to do this. But Cyrus, why don't you kick things off with why associations should amend or restate their governing documents?
Sounds good. So there's a lot of reasons to amend and restate governing documents. One thing I want to point out kind of from the outset, the title of this presentation used the word rewrite. And we get that question a lot. Is it worth rewriting our governing documents or restating them? And I can tell you right off the bat, in most cases, rewriting governing documents, actually going through your current documents and just revising them, that would be a nightmare. It would be, I would say, more expensive, probably 10 times out of 10. So that's why I would say most associations are going to be looking at a full restatement of the governing documents, just starting over with new documents. Chances are most of your documents are really outdated. So it doesn't make sense to go through just line by line and try to update really the whole document. It really makes sense to restate everything. As far as kind of the big ticket items or takeaways, as far as why you want to restate governing documents, alignment with current laws, that's certainly key. The Davis-Sterling Act, the primary body of law governing HOAs in California, it's changed a lot over the years. And I would say maybe 40 to 50% of the governing documents we restate, they predate the Davis-Sterling Act. So they don't even take into account any of the laws in Davis-Sterling. I'll also point out most governing documents are really unclear. They're drafted unclearly. So not just based on prior laws or not just predating the current laws, they're just drafted poorly. They don't address maintenance in a clear manner. I would say most of them don't contain maintenance charts or matrices, which we'll discuss later on. And they just aren't streamlined for all of the operational trends that most associations are trying to take advantage of now.
Okay, so when you're looking at whether to amend versus restate, I think first let's define what amendment would be. An amendment to the CC&Rs or bylaws occurs when there is one provision or a few provisions that require change. And this is really a big consideration for associations, especially when you look at the potential costs of restatement versus amending. There may be very pressing issues that your association sees where just a couple amendments would be justified under those circumstances versus completely redoing the entire document. Perhaps your association is just wanting to deal with rental restrictions, and so you just do one amendment to your CC&Rs with respect to just rental restrictions. But conversely, if you have a very old document or you have a lot of issues that you're seeking to address with the amendment process, perhaps you consider restatement of the entire CC&Rs and the entire bylaws. And Swettles and Gottlieb has plenty of programs that are fixed, and we can go into those a little bit later. But restatement, by definition, would be you're basically taking your current CC&Rs and your current bylaws and completely redoing them. And what we would do is submit a questionnaire to your association. You would answer various questions about all the different topics or issues that you seek to deal with, and then we would tailor and provide a completely brand new CC&R document and bylaws document that that we would just adjust and tailor to your association, and then you know get board approval before we send it out. But we'll go through the timeline and all of the ins and outs a little bit later. But just know that amendment is just you're just amending one or a few different provisions. Restatement is you're completely redoing the CC&Rs or the bylaws document. Okay, Cyrus, why don't you talk about the definitions?
Yeah, so we get a lot of questions about, well, can we adopt a certain idea or requirement or obligation? Can we put that in our rules? Can it be in a policy? Can it be in the CC&Rs? Does it have to be in the CC&Rs? Can we get away with it in the rules, et cetera? So it's good to just kind of touch on some of those differences here. A rule is a regulation or policy that I would say the general rule of thumb would be that it deals with the operation of the development. It's more so focused on the common areas of the community. The Davis-Sterling Act does define what you're allowed to, kind of what categories or topics you're allowed to cover through rules. But generally speaking, we're talking about common area issues that really impact the community as a whole. We're not as much talking about specific restrictions on the use of your property as a homeowner, which is probably maybe one of the most significant things that you would find in any homeowner association governing document, because it is restricting your use and ability to use your property as a homeowner. And that's where a covenant or equitable servitude comes into play. A covenant is an agreement that binds an owner and it runs with the land. So it binds all future homeowners as well. And that's really what the CC&Rs are. The CC&Rs are a declaration of covenants, conditions, and restrictions. So really it's referring to covenants. And that's why it's really, again, going back to the kind of the idea of rule of thumb, that if you're trying to restrict the use of property as to an individual owner, you want to do that through a covenant. And that's why the CC&Rs are truly maybe the most appropriate forum or location to include a lot of the restrictions that you find nowadays, such as rental restrictions, restrictions against parking, restrictions against how many pets you can have at your in your unit or in your lot. So important distinction there between what can we adopt through a rule versus what can we adopt through a covenant, in this case the CC&Rs. And a policy, you hear that term a lot, and it's really just a matter of preference from a terminology standpoint. A policy really refers to operating rules or a set of rules. So it's really just, some people will use the term rules, some people will use the term policy. Policy might infer that there's a standalone set of rules, maybe for a particular topic, like a charging station policy or a policy regarding election rules. So it might not be a general handbook of rules that you see, but important definitions to keep in mind.
Okay, and what to put where? Yeah, I mean, so when you're looking at all of the association's governing documents and you're trying to figure out, whether the particular issue is dealt with in the CC&Rs or in the rules or in the policies, you really have to look at how intrusive it is that the proposed rule or covenant is going to impact your community, what type of behavior is being impacted. And I guess, for example, if let's say you wanted to restrict smoking inside someone's unit or inside someone's exclusive use common area, that's pretty intrusive. It's probably going to be a controversial, intrusive type of restriction. And so that would probably be something that you would want to have in your CC&Rs as opposed to your rules and regulations. Does the activity or behavior impact the entire community, or would it only select a few homeowners? So you have to look at that issue as well, because if you're just talking about regulating parking, say you want to regulate common area parking, and say that in a particular community, you're you have to park a certain way, or you have to um, you're limited in the number of hours, or whatever the particular parking regulation. It applies to the entire community, but it just applies to common area parking. So that may be something that you put in your rules. You also want to look at how flexible you want the particular rule to be, because um, if it's something that you want to be permanent, that's going to survive from several elections in the future, then that would probably be something that you would put in your CC&Rs, versus if there's a rule where you could see might be subject to change, or something that the association may want to change easily in the future, you would put that in your rules and regulations, so you wouldn't have to obtain membership approval every time you change it. So you kind of look at these factors to determine whether you're putting it in the CC&Rs, if you're putting in the rules and regulations, if you're dealing with election issues or quorum, or governance type issues, whether you put that in the bylaws. So be sure to consult your legal counsel about the particular issue that you're trying to address, and then using these factors, figure out which governing document is appropriately going to be dealing with that issue.
Yeah, and we have a quote here. It's kind of something we like to say. Effective governing documents can resolve many issues within an association. So, governing documents are a lifeblood of an association. Sometimes we'll refer to the CC&Rs as the Bible for your association. So, bylaws are important because they deal with the operational aspects of your community from a business standpoint. How does your association run as a nonprofit corporation and business? Whereas the CC&Rs are a land use document, important to address and regulate all land related issues in the community. So they both serve important purposes. But the bottom line is, with both of those documents, and with all of the rules and policies your association adopts, having effective governing documents that are transparent, clear for the board, clear for homeowners, clear for management, clear for future buyers, et cetera, that will resolve hopefully most, but certainly many issues within an association.
Okay, and why choose to amend? So again, kind of going back to what we were alluding to at the beginning, you have to focus on what is your objective, what is your goal as an association. You look at what you're trying to accomplish, and then you figure out something that's going to fit within your budget. That in looking at all the factors, what will accomplish your goal for the least amount of cost. Are you just trying to address just a few provisions, or only a few provisions in your governing documents requiring modification? What's your cost budget? How much money do you have in your budget for this purpose? Is membership approval going to be an issue with regard to what you're seeking to change? And the reason I say that is because some associations may say, well, we're just going to amend the quorum requirement, and we're going to bring the quorum percentage down to something more reasonable so we can have annual meetings. That's not going to be a very controversial issue. So membership approval is probably not going to be a big deal. Whereas if you're going to impose rental restrictions, or you're going to impose restrictions on residency, or something that might potentially be controversial, where obtaining membership approval might be a challenge, then you look at that as well. So you look at all of these factors. You look at what you're trying to accomplish. You look at how much everything is going to cost, and whether the association can afford it, and then you make a decision whether to go forward or not. So but why choose to amend it? You know, you got to go back to your objective. And if you're just choosing to amend just to amend, that's not really a good reason. But if you're having problems in your community, or you foresee that there will be problems in your community that amendments could potentially address, we're going to be going into later on in the presentation, maintenance obligations. If you're getting a lot of pipe leaks, or you see the potential pipe leaks, and then you're trying to figure out who's responsible for what. Um, an amendment may save your association a lot of money down the line. So that would definitely be to the association's benefit to amend your governing documents to clarify who's responsible for what component, or who's responsible for the damage, or how you're going to address the insurance issues. So just looking at all these factors before you decide to move forward, I think is in your best interest.
And we mentioned it earlier, but I'll just kind of comment again. Timeline is also important, and it kind of goes hand in hand with the issue or the idea of importance. A full restatement project is going to take a long time, so you really have to be committed to it as an association or as a board. There are going to be multiple drafts going back and forth and flying around. There's going to be a lot of review. You're probably going to have a feedback period, a review period from the homeowners. So there's a lot that goes into that. If you have something like Brian pointed out regarding an important maintenance issue that could save the association money in the near term and long term, but it's really important that it gets done as soon as possible. That's why you might choose to amend rather than restate, as we alluded to before. So timeline is going to be important. And so kind of the contrary to that is the restatement process. So one question we get a lot is, well, if the law says what it says right now and our documents are outdated, aren't we still subject to the law, or don't we still have to follow the law anyway? So do we really need to restate our documents? That's a really good question. And the answer is it might not be as simple as you think. It can kind of go both ways. You don't have to restate your documents solely because they're outdated or they don't reflect the current laws. But there's a lot of issues that come up if you don't have documents that are reflective of current laws. First and foremost, you're not going to have a clear guide as to what the laws are. And part of the restatement process is to ensure that there is transparency, right? That everybody knows what's going on. Everybody can point to a page in the CC&Rs or in the bylaws and say, hey, that's the obligation here. This is what I'm entitled to. For example, annual disclosure requirements that are usually included in the bylaws. And I do see them from time to time in CC&Rs. If you don't know what those are, you have to consult. You might have to go online to figure it out. You don't know what you're looking at online. You might have to consult legal counsel. So you could incur some legal fees. You could certainly take more time just trying to figure something out. Whereas if you have that clearly set forth in your document, it basically prevents all of those issues, and you have a guiding principle to go off of at any time. Another kind of complication that's worth mentioning: some of the laws defer to your governing documents. Alternatively, some of the laws say, notwithstanding whatever's in your governing documents, the law controls. So you have these two kind of competing type of provisions in the law as far as control and what controls in the law. So you could have something in your governing documents that you're not taking advantage of, that the law allows you to take advantage of. You could also have something in your governing documents that's just simply in violation of the law. And you could be doing something thus in violation of the law. So it actually is important to reflect to current law, because you have these two different scenarios that exist. I'll just say financially, a restatement project, as opposed to kind of going through and just performing a few amendments here and there, kind of piecemeal, it's almost always more efficient from a financial standpoint, because to go through one by one, and I'll just use an example, make 6 or 7 amendments to your current documents, that there's a lot of work goes into that, and you have to make it really clear for homeowners what you're doing. And usually, if you're proposing 6 or 7 amendments, that's 6 or 7 votes on a ballot that people actually have to mark off. And homeowners have trouble as it is sometimes understanding how to complete and fill out a ballot. And so, and it can be confusing, especially when there's several amendments being proposed. So I think it's important to keep that in mind. And inevitability, I think most associations can reasonably expect that, a restatement is probably a good idea, every, depending on the documents, maybe 20 years or so, 20, 30 years. I think there's some give or take there. Um, what we can tell you is in 2014, the entire Davis-Sterling Act governing associations was recodified and basically revamped. And that overhaul was kind of maybe a key date as far as restatements go, because really since 2014, we're finding that a lot of associations are restating. And there are changes in the law every year here and there, but not like in 2014. And we're not really expecting a change like that again. So that's another reason why most associations governing documents are going to be outdated pretty comprehensively at some point.
Okay, and documents to consider. I think every association is different in terms of the documents that you're considering. Some associations, your CC&Rs may just be called Declaration of Covenants. Other associations might say Declaration of Covenants, Conditions, Restrictions, and Reservation of Easements. The titles of the documents are mostly, they vary from association to association. And likewise, the rules and regulations and policies and all of the other potential governing documents are going to be different for your association. So you'll just have to look at your particular association and determine which documents you're going to consider. I have some associations where the issue of the number of directors is addressed in the Articles of Incorporation. Other associations where that issue is addressed in the bylaws. And so you could just see that, depending on how the original drafter of your community or the developer set everything up, is going to dictate, which documents you're going to consider in a restatement or an amendment process. And likewise, if you're going to be focusing on a particular issue and you make an amendment, it's important that you look at all of your governing documents to determine whether or not multiple documents need to be amended for that change, because you may make a change to the CC&Rs that is also where that issue is also addressed in the bylaws or the rules and regulations. And so one change to one document would also result in you having to update that provision in other documents as well. So it's important.
I'll give a real life example, Brian, of what you're talking about. Recently, we had to amend a bylaws provision regarding cumulative voting. And you would think that might just be a bylaw provision. Well, actually, a lot of outdated or older CC&Rs address cumulative voting. And if you don't catch that and you don't go into the CC&Rs and figure out, oh, hey, there's a cumulative voting provision in the CC&Rs, we actually have to amend both documents. And that can lead to some other complications because the CC&Rs could have a different approval requirement than the bylaws. So there's really a lot of things that go into it. So Brian's point on kind of consistency and making sure you do the due diligence there is key. But that's a real life example we just saw that was a little more complicated than we thought it was going to be originally.
Yeah, it's a good point. And the last thing you want to do is create ambiguity where you don't need to, where it's going to lead to a dispute or litigation. You don't want that issue to be in front of a judge where it's going to create risk for your association. So, so the best thing to do is just make it bulletproof. Make sure that when you make a change, that you make that same change across the board and you address all documents. And so, from that standpoint, when you're looking at amending your governing documents, just make sure you include a review and a complete review of all of the documents in that universe of governing documents to make sure that it's effectively an effectively made change that's not going to subject you to potential litigation later on.
Yeah, so here's an example of a lot of laws that have changed. And I alluded to this a little earlier, at least a couple of these, but there have been a lot of changes over the years. And the Davis-Sterling Act in 2014 is probably when it most noticeably was overhauled. And, when we draft governing documents, we actually do our best not to cite specific code numbers, code section numbers, because we don't want to have to go back and change them or find that they're outdated, or maybe they change from time to time. So we actually do our best to avoid that. But 2014 was a major cause for restatements, I think, for many associations. 2020, I think a lot of us are familiar with SB 323, kind of another key date or key marker in a lot of the changes in how we conduct elections for associations. And actually, it's not listed here, but going back to the Open Meeting Act, mid 2000s. So, a lot of laws regarding elections seem to have changed in the last 20 years. So important that those get addressed appropriately in your bylaws, which is going to be typically the document that addresses those, but also your election rules. So, a policy or set of rules addressing election issues. New laws regarding electric vehicle charging stations, solar panel installations. California has public policy concerns regarding associations potentially restricting owners from installing these kind of environment-friendly equipment or technologies. So really important that those get addressed appropriately, because certainly most outdated or older documents are not going to address those. And ADR, IDR, notice and disclosures, a lot of the annual disclosures and dispute kind of rights, resolution rights that exist for associations and for homeowners at associations, they've all been implemented in the last several years, especially since 2014. And important that all homeowners, I mentioned this before, it's really important that all homeowners know what they're entitled to on an annual basis, and that the board knows what the association is supposed to disclose on an annual basis. It's equally important that the board and management are clear with respect to what are the notice requirements in the community. If it's a board meeting notice, or you're posting a rule change, you're sending an amendment out for a vote. All these different types of communications and disclosures, they all carry with them various notice and obligation standards. So important that all of these laws have changed in recent years. Important that those get addressed in your governing documents.
Yeah, exactly. It's very important. So member approval not needed for certain situations. Obviously, if you have discriminatory language, some of the older CC&Rs might have discriminatory language dealing with children or race, or other weird things that developers way back when decided to put in their documents. You don't need membership approval for those types of amendments. Correcting cross references to the civil code. There was recent legislation that was passed saying that if you're just changing the code numbers, you can do that without membership approval, although you still have to record and do several procedural steps so to comply with that statute. Removing language that is illegal as a matter of law with limitations. So some language, in your CC&Rs may be contrary or conflict with current law. In some cases, you're able to just, make the change. Other times not. It just depends on the particular issue that you're dealing with. And again, doing a thorough review of your governing documents to determine what needs to be changed and whether membership approval is required. Um, some of the discriminatory language that we see in association governing documents mostly has to do with children. And if you have rules and regulations where it says the word children, that should be an immediate red flag where you look at it and say, is this discriminatory on its face? um, and then making that change appropriately. But I think it's just important to know right out of the gate whether if the particular change that you're making to your governing documents is going to require membership approval, because that's a much different procedure than if membership approval is not required. And likewise, if lender approval is required or if city approval is required, you look at all of these things that may impact your potential amendment and say, okay, based on our objective, based on the amendment that we're trying to make, do we need membership approval? Do we need lender approval? Do we need city approval? Because that will impact costs, that will impact the procedure that you're using, and potential approval of those things is also a consideration. It's much easier to get lender approval versus membership approval, and we'll go into that. But anyway, looking at your governing documents and making that determination out of the gate is going to save you a lot of time and a lot of headache.
Yeah, and I'll mention, Brian, when we provide proposals to associations for restatements, um, and even amendments as well, we tell associations up front in our proposals, hey, we've reviewed your CC&Rs. They actually have a lender approval requirement or a city approval requirement. So it's really important to point that out from the outset so that you have an idea what your costs are. You might get a proposal, and quite frankly, it might look really appealing, but you're not factoring in all of the lender approval costs that are going to be required if there is lender approval required at your association, or same with city approval. So it's really important to get a true and accurate idea of what the all-in costs are going to be for an amendment or a restatement. So it's a really good point.
Okay, what about expiring documents?
Yeah, this is interesting. I actually dealt with this a few times, including recently, and these are you have some older CC&Rs or outdated CC&Rs that basically have a kind of a finite expiration date, and it'll just say the CC&Rs expire on, December 31st, 1977, or 2045, and the CC&Rs expire on that date. So you'll find a lot of goofy or strange provisions. We don't really need to get into the rationale or reason why these provisions exist, but there's a lot of kind of hardcore legal principles at play here. I'll call out the rule against perpetuities. We won't talk about it, but I think the whole goal is to ensure that when you're recording restrictions against land, they can't just be basically in effect forever. And you have to do what you can to try to include some kind of finite kind of start and stop dates to those restrictions. I think most associations, what they're doing is they kind of have an automatic evergreen renewal provision, which will basically say that the CC&Rs just renew automatically every 10 years, unless the association makes a decision to terminate the CC&Rs. So I think that's important to you'll consult with your legal counsel on something like that. If your CC&Rs actually are going to expire, you need to jump on it, especially if that date is upcoming. We had to make I would say a full court press and a mad dash to amend one association CC&Rs, and they were actually going to be undergoing a full restatement, but because their CC&Rs were expiring kind of earlier, more immediately, we actually had to amend it right on the spot, get it out to a vote, and get everything done really on an urgent basis. So I think Brian maybe can, comment on it from a litigation standpoint, but if the CC&Rs expire, that could lead to a lot of nightmares, probably in court, probably with a conservatorship, or maybe lenders will, no longer provide financing in the community. That could really be a kind of a, maybe one of the most extreme things that could happen to an association.
Yeah, I mean, I think it would mean that your association no longer exists. I mean, there is, you could obviously, you can create new CC&Rs, but the problem is that you would need 100% membership approval, because once everything is sold from the developer to the membership and you have a subdivided property, all of the interests need to sign off on whatever new covenants you create. So as soon as that CC&R's document expires, um, you're out of luck, so to speak. And Cyrus is right. You really want to pay attention and just create an evergreen, an ever flowing provision where it just automatically renews, like Cyrus said. So you can get away from the rule against perpetuities, but at the same time, make it easy to deal with, where you're not having to constantly monitor. Are we pushing up against the deadline where this thing is going to expire? Okay, so common CC&R amendments. Again, this all depends on your community, what issues you're either facing or potentially going to face. But some of the common provisions that we deal with: rental restrictions is a hot topic, hot button issue. Collection provisions, which we're going to go into a little bit later. We sort of alluded to it earlier. Maintenance and repair responsibilities, that's a big one if you have a pipe leak or water damage. Insurance requirements kind of ties in with that. If you have a lot of water leaks in your community, but homeowners are not getting their HO6 policies, or you're experiencing a lot of claims on the master HOA policy, you're having to deal with cancellation or premium increases. So you're going to want to deal with insurance requirements, pet restrictions that, in California especially. There's just, people, I think homeowners, they love their pets. And, if you're going to go from 3 pets to 2 pets, or if you have, a lot of homeowners that are just, have large dogs or aggressive dogs, pet restrictions becomes a hot button issue. So you want to, implement a policy that makes sense for your community, depending on the size and the dynamic of your community. Nuisance restrictions, that it's kind of it's a broad term, but the more that you can clarify exactly what is and what is not a nuisance is also a common provision that you deal with. Architectural and design control. If you're in a planned development with single family homes, and in your community there's a lot of architectural changes, you're going to want to have a solid architectural and design control provision in your CC&Rs and architectural guidelines, to deal with those potential issues that might come up. Vehicle and parking restrictions, especially in condominium developments, this becomes an issue, because if the developer decides that there's going to be a limited number of parking spaces compared to the number of units in your community, there's always a fight over parking and who's parking where and how long you can park for. Safety and security disclaimers, and this would go for pretty much any provision that you want to create that is going to insulate the association from liability. Whether you're dealing with water claims, or if you have security cameras, or if you have a security guard. Sometimes what goes hand in hand with all of that is creating a provision in your CC&Rs that will protect the association, protect the board, protect management if someone decides that they're going to sue over a security issue or safety issue. So anyway, these are just some examples of the the types of provisions that we typically see associations want to address in their governing documents. Okay, what about rental restrictions?
Yeah, rental restrictions are, Brian mentioned, they're a hot topic. And part of the reason they're a hot topic is because of a recent law, AB 3182, effective January 1st of 2021. So we're still kind of in the shadow of it, and we're still dealing with it. But rental restrictions are key. A lot of communities are finding that there's an influx of buyers who want to use the property for short-term rental purposes, for business purposes. There's also a housing shortage, quite frankly. And even though I think a lot of us would say, well, homeowners associations don't really seem to be the answer there, it's still the case that a lot of people are seeking rentals in California. So with all of that said, associations are looking to amend their governing documents to implement rental restrictions. We take the position more so that rental restrictions really belong in the CC&Rs as opposed to rules. Sometimes you can implement some rental restrictions in the rules, or at least, you know, maybe in some cases reiterate or mirror what's in your CC&Rs through like a rental policy. But really, you're kind of putting the association in the most defensible position by including rental restrictions in the CC&Rs. If you are imposing a rental restriction, you have to look at whether, you know, are certain owners going to be grandfathered in. Certainly with like a leasing cap, for example, if you're going to all for the first time in your community's history, implement a restriction where, for example, only 25% of the units in the community can be rented out. If you implement that today, well, all current homeowners as of today are going to be grandfathered in because that's required under the law. So important to know that. Rental restrictions also created an administrative kind of angle to this. Are you going to maintain a waiting list? How are you going to keep track of things? So the more you can include in the actual amendment, in the language of the restriction, the more guidance management has, the more guidance the board has, and, you know, the less kind of room there is for any arguments or maybe even litigation later on from any homeowners. Yeah, so there are FHA approval concerns when you're implementing rental restrictions. So there's really a lot that goes into rental restrictions. I think one thing that's kind of we'll monitor as we go along, and it's certainly a conversation you should have with your legal counsel, is Brian mentioned earlier that there are some express provisions in the law where that allow you to amend your governing documents without a membership vote. AB 3182 actually requires associations to amend their governing documents if you're not in compliance with the requirements of AB 3182. So you're actually required to do that. However, it doesn't say you can do it without a membership vote. So that's a little bit of a gray area. What if there's a no vote? Does that make sense logically? Kind of seems like it doesn't. So, you know, I think that's an important conversation to have with your legal counsel, you know, depending on what it is you're actually amending. So I think that's an important kind of angle to maybe keep in mind for the future, because different legal counsels or attorneys might have different opinions on that.
Okay, another hot topic is collection procedures, and you know, after the global pandemic, and you know, perhaps foreclosures and or bankruptcies start to accelerate a little bit. Hopefully not, but if they do, a lot of associations are going to be looking at their collection procedures and improving them, hopefully to protect the interests of the association and its members. Some of the things that you want to look at is you want to make sure that your governing documents are accurately reflective of the current civil code. You know, and as Cyrus was mentioning earlier, you want to take advantage of the provisions that you can. You know, sometimes, you know, the civil code will say that, you know, the association can charge up to 12% interest. And what if your CC&R says you can charge 5%? Well, you have to use the 5%, but you can change your CC&Rs to make it 12% to make it more advantageous to the association. Same goes with lien and foreclosure rights, making sure that you have all of the up-to-date civil codes and applicable law dealing with liens and foreclosures, and that you're taking full advantage, that you have both the right to foreclose non-judicially as well as judicially, and that, if there is a foreclosure sale, or if there is a foreclosure in process, what are the association's rights in, during that procedure. Do you have an assignment of rents, which means that if a homeowner who's renting their unit is not paying assessments, is the association able to, do they have an assignment of rights, which means that they would be able to go directly to the tenant and say, you pay your rent payments directly to the association until the owner's account is up to date. Those are important provisions, because it's giving the association additional leverage and additional tools in which to collect assessments. And assessments are the lifeblood of the association, meaning that that's the only source of income that it has. It doesn't, it can't sell T-shirts on the side to generate additional income. That's the only thing that it can collect as assessments. So it's very important that delinquent percentages stay low, and that goes hand in hand with mortgage approval and sales. Because if a prospective buyer comes in and says, well, I want to buy at this community, and the lender says, oh, no, their delinquency percentage is way too high, it could impact the saleability of that unit and the market values of the properties in that community. So it's important that you have very strong and fair collection procedures in your governing documents.
All right, maintenance and repairs. This is a big one. Probably, one of the, I would say, 5 most important changes you can make to your governing documents, and maybe one of the 5 most kind of prevalent changes requests or of changes we're getting from homeowners associations. So the goal is to clear up confusion. I think most outdated governing documents, they're overly simple to the point where they're vague. A lot of them predate the Davis-Sterling Act. They don't address or take into account exclusive use common areas, or kind of the components or areas of a unit or on a lot that are on the boundaries. Well, what do you do with what's on the boundary? Is that really within the unit? No, it might not be. So I think that's key. A lot of old governing documents will just say the owner is responsible for their unit and everything they're in. But that doesn't tell you a lot. You need to clearly define the boundaries of the unit. Then you need to get into, well, who's responsible to maintain, repair, replace, paint, et cetera. So really important. And I would say the most kind of common way that associations are addressing that now is through a matrix, which is a chart, rows and columns, and it really seeks to clarify who's responsible for what from a maintenance, repair, and replacement standpoint, by really breaking everything down into line items, and basically saying, hey, for this component, here's who's responsible. It's either the owner or the association, and just going kind of all the way down the line through all of the components in the association. And when you amend your documents, it might make sense to kind of stay consistent with or maintain some historical practice, but it's also the opportunity to make important changes, as Brian alluded to earlier. You might have pipe leaks, or the natural age or kind of deterioration or maturity of the community, which might result in some needed changes as far as who's responsible for what. So that's something to keep in mind, and a matrix is a really good way to address that in the document.
Okay, I was talking about this earlier, insurance provisions. Sometimes you have a no-fault water loss that causes significant damage to both separate interest and common area components. And it's unclear in the governing documents who will pay for the deductible. in the master policy if there's a claim that's made, or who's going to pay for the deductible for the HO6 policy that might be in place. Having a provision in your governing documents that addresses that issue clears it up right away. It makes it very easy. You don't have to, have a fight about who's going to pay for what. Separation of coverage is also very important, and you want to involve the association's insurance broker into this discussion because, one, you want to set the policy limits compliant with the Davis-Sterling Act and the applicable law, but you also want to tailor your insurance coverage requirements to the particular community. Some CC&Rs I see where, you have certain required insurance that may not be, either feasible or appropriate. Like earthquake insurance is a very, very controversial issue. Some homeowners want it, others don't. And if you have a provision in your CC&Rs that says you have to have it, then you have to have it. Same with flood insurance and other different types of insurance. But you want to make sure that your governing documents, reflects the policies that are appropriate for your community, and it's not going to be a one size fits all. And again, you want to involve your insurance broker to have that discussion with, look at all of the different carriers available in your area, look at the pricing, look at the different coverages that are available, and make sure that your insurance provisions accurately reflect the what the policy should be for your community.
Pet provisions. Brian commented on some of the the important provisions relating to pets, but I'll just kind of touch on it real quick. Really important that you address the number of pets that you actually want to set forth as a maximum in the community. A lot of older documents don't do it. They just say a reasonable number of pets is allowed, but that doesn't really give a lot of guidance. And the concern there is if you treat one homeowner differently than another because you don't have this set maximum in place, that could really lead to some discrimination claims, claims of unfair treatment, disparate treatment, selective enforcement if you enforce something one way versus another. So that's important. Type of pets. This is probably referring more so to, for example, a weight restriction, which is something we see from time to time. Personally, I might not be as big of a fan of a weight restriction because I think nuisances are still nuisances regardless of weight and size. But you might have a situation where your community, based on the building, weight issues actually impact the common areas in a way that might not apply in another association. So important consideration. Dangerous animals or aggressive breeds. That's a conversation you need to have with legal counsel. There's actually laws in California that are pretty strict in how far you can go to limit quote unquote aggressive animals or potentially dangerous animals. It's more so based on the conduct. You can't really focus on breed, but that's something you would discuss with with legal counsel who's drafting any provision. Pets can always still create a nuisance. So it's important to kind of tie in your nuisance language with pets. If pets leave waste in the common areas, that can be a nuisance. Incessant barking, that type of activity. Registration. Some associations do go a little bit farther in trying to regulate. Well, hey, if you have a pet, we need to have a kind of a record of it based on our community, et cetera. So I think that's important to keep in mind. And finally, I'll mention, even though it's not here, you have to take precaution with respect to assistance animals. There's all types of assistance animals out there. And in most cases, I would say they're not considered pets. So you can't even view them as pets because they offer a service or they provide assistance to people who need it. And so there's a lot that goes into that. And a lot of that comes from some of the FHA guidance. So important to keep in mind that might be something you address in any pet amendment or provisions regarding pets.
Okay, and then nuisance restrictions. I think what a lot of CC&Rs will do with regard to nuisance restrictions is um, have a definition or lack of definition that is not very clear in terms of what a nuisance is and what it is not. But I think more importantly, as we're seeing new types of nuisance disputes, neighbor to neighbor disputes, and potential harassment and other types of discrimination claims that might be thrown out in your community. It's important to have a clear definition of what a nuisance is and what it is not, and ensure that your nuisance provision um, completely encompasses the types of activities or potential activities that could could be a nuisance or considered to be a nuisance. Having provisions that allow your board of directors to interpret the provision and make certain calls, difficult calls on what a nuisance is, what it is not. um, a reasonable person, it always differs. And if these things go to court, if they are in a dispute, it's better to have a clarifying provision that deals with nuisance behavior. And having flexibility in the provision as well is important, because there may be activities or things that you didn't think of would be a nuisance, and you see a dispute or a series of disputes that play out, and you want to be able to adjust your rules and regulations to reflect that, or have a policy that deals with certain behaviors. So a very important provision to deal with in your CC&Rs, making sure you have appropriate definitions, but at the same time allow flexibility, so that it's going to allow the association to adjust with the times, to adjust with the various things that the association may be experiencing as time goes on. What about smoking?
All right. Well, I know you deal with a lot of smoking issues, both inside and outside of court, Brian. So, we could probably realistically have a conversation about this for a couple hours.
Yeah.
Um, but we've seen um, a lot of movement with respect to smoking restrictions and CC&Rs in recent years. Whether it's making the entire development or community non-smoking, whether it's restricting smoking just in the common areas, whether it's restricting smoking on the unit, within the units, within the balconies, patios, et cetera, some combination of all of the above. So I think a good rule of thumb is if you're just dealing with the common areas, I think there's flexibility to impose smoking restrictions through the rules. If you're just talking about the communal facilities and common areas. But if you're talking about portions of a unit, Brian mentioned the word, it's more intrusive earlier, patios and balconies, that's the kind of thing where you're going to want to impose this type of restriction through the CC&Rs, and it can be controversial. At the same time, consider that even though smoking disputes and situations can be problematic and controversial, I think we would use the phrase that more people don't smoke as compared to do smoke. So you have that going for you. Actually, a lot of cities and counties are starting to implement smoking restrictions. So something else to keep in mind, especially in Southern California generally. So, important. One final consideration is you have to know what the elements of the unit, how they're constituted. So for example, in some communities, balconies might be a part of the unit, whereas in other communities, a balcony might be considered exclusive use common area. So, you might not think there's a lot of kind of real life significance there, but that actually, depending on what your legal counsel says, there might be a little bit more leeway to impose restrictions when you know that that area is actually a part of a unit versus technically a common area for exclusive use. So kind of a little nuance there, but that's something else to look out for.
Okay, parking and vehicle restrictions. You want to make sure that your governing documents deals with um, towing procedures. So whether you want to tow, and if you are going to tow, um, what the requirements are going to be, and making sure that those requirements are consistent with the Davis Sterling Act and other applicable law found in the vehicle code. Um, guest parking is always a point of contention, especially in condominium developments where there's limited parking, and you may have a situation where you have owners that have a number of guests and they want to use the guest parking, but that may be taking away parking from residents, and then residents get upset about it. So there's always this, you know, um, animosity that might be created just with respect to guest parking. Appropriate use of the parking spaces. So making sure that if you don't want to have people washing their cars in the community or making repairs to their cars in the community, or various other activities that could potentially happen in a parking space, dealing with those issues up front is always going to be better for your community. Make sure everyone's on the same page in terms of what the policy is, um, and then it's accurately written in your rules and regulations or your CC&Rs, so that if someone violates it, that it can properly be enforced. So there's a whole host of different issues that could happen with respect to parking and vehicle restrictions, but uh, this is part of the process of when we amend your governing documents, we'll probably give you a questionnaire and ask you a bunch of questions about these types of issues, try to figure out what your goals, what your objectives are, and tailoring the particular provision to those goals.
Architecture and design is, I mentioned earlier, maintenance being one of the five most important maybe sections or items in a CC&R restatement or amendment. I think architecture and design is as well. A lot of old governing documents have very little in the way of regulating or addressing architectural changes. It might just say, no improvements, maybe, maybe modified without association approval, and that's all you have. The more you have on this, the better. And the reason why this is so important is because your CC&Rs are a recorded document, and they place all future homeowners on notice legally of what's in what's in the CC&Rs. And that really comes into play with architectural and design changes, because there are countless cases in California and certainly nationally where the subject of the dispute and of litigation is some kind of architectural modification that wasn't approved, that wasn't allowed. A lot of times it's a new buyer who comes into the community and they kind of do what they want. And if you have provisions addressing architectural and design changes, what are the restrictions? What are the time periods for approval? What does the board or the architectural committee have to review, et cetera? You're going to be able to look at somebody who is in violation and say, no, there's no arguments here. What's in our documents. It's in our CC&Rs. It's clear. We also have architectural guidelines that lay out all of the actual details, like the standards, the color palettes, all of that stuff. So, really important. The aesthetic uniformity and character of the community is one of the primary purposes of a homeowners association. I would say that, along with maintaining the common areas, that's truly the purpose of any homeowners association. So, there's an inability to maintain that aesthetic uniformity if you don't have proper architectural and design language.
Okay, and we also touched on safety and security concerns and waivers and It's really, associations are nonprofit corporations for the most part. Sometimes they're unincorporated associations, but they're nonprofits, and the association has limited resources, a limited budget, and limited income. And so, from that standpoint, anytime you have potential liability or a potential opening for someone to make a claim or a lawsuit against the association, that's why you want to be proactive and deal with those potential issues in a discussion with the association's legal counsel to determine what protections can be put in place looking forward if there are potential claims that are made against the association or against its board members or against its management company. And so you have safety and security disclaimers are just some of the different types of provisions that you can put in a CC&R's document that will protect the association. But you're basically just saying that, like if you have security cameras in your community and one of the security cameras malfunctions, or if somehow it's not playing that particular day, that you have appropriate language in your governing documents that covers the association in that event. Because if that happens and someone's car gets stolen or someone gets assaulted, they're going to look to the association for the footage on that particular incident. And if the camera is malfunctioning, they're going to try to probably sue the association and say, well, had the camera been working, this wouldn't have happened, or I would have had more additional recourse, or whatever the case may be. So that's just one of the examples of something that could happen where if you are proactive and you include an appropriate provision in your governing documents, that if it does go to court, the association has some level of protection, to fend off those types of claims.
All right, shifting, a lot of the issues we've just discussed were use restrictions, right? Impacting the use of your property, whether it's your property as a unit owner or a lot owner, or the common area restrictions. So shifting gears a little bit, but still important, are changes to the bylaws. The bylaws are an operational document. They're a business document. They're not recorded in the county. They don't impact the land really. They impact how the association is governed and run from a business standpoint. So common changes is board composition, as well as election procedures, especially in light of SB 323 in 2020. A lot of associations are seeking to clarify and amend what are the requirements and procedures for elections, because they've changed. A lot of bylaws have outdated language on what qualifications are there to be able to serve on the board. Well, SB 323 limits what restrictions can now be imposed, what qualifications can be imposed. So you might amend your bylaws to address that. A lot of associations, unfortunately, have a lack of participation. A lot of people don't want to serve on the board, or at least there's not as much participation. So in that case, some associations might want to shift to staggered board terms, or maybe board elections where everybody serves 2-year terms every other year. So you don't even stagger them, meaning you can kind of skip a year. So you save some money there. So there's a lot of ways, while at the same time maintaining continuity on the board. So there's a lot of ways to look at board composition and election issues, but those are probably the key changes to bylaws, as well as disciplinary measures. Proper notice and hearing requirements should be explained clearly in the bylaws, because your association might not be taking advantage of certain requirements that exist in Davis Sterling, and you might have more restricted language as far as providing notice to homeowners before holding a hearing. A lot of times you might find dollar amounts. So if you're going to impose a monetary fine on a homeowner, your bylaws might contain a restriction limiting it to $25 per violation. that's not something you want in your bylaws. You want that removed. Those are really some of the kind of most, I would say, prevalent changes we've been making to bylaws and kind of in the last couple of years.
Okay, operating rules. This, again, going back to membership approval versus not non-membership approval type items. Operating rules deal with rules and regulations that the board of directors can change. And of course, you have to send it out for a 28-day comment period to the membership, but ultimately the board is vested with the right to make a decision in terms of whether that rule change is implemented. Rules kind of fall towards the bottom in terms of the hierarchy of governing documents. CC&Rs and articles of incorporation are up there along with the bylaws, but the rules and regulations are down at the bottom in the order. Alignment, you want the operating rules to be truly reflective of what your bylaws and CC&R say. Sometimes your CC&Rs and bylaws may leave open a particular issue to be addressed by the operating rules, but you just want to make sure that the language in your rules and regulations is not in conflict with the bylaws and the CC&Rs, because then it will mislead or potentially lead to a conflict about a particular issue. The procedure it's pretty simple. You send it out for a 28-day comment. You get input back from the membership about how they feel about the potential rule, and then the board makes a decision about whether or not to implement it, and then sends out notice to the membership regarding its decision. Sometimes, if you make changes, then you have to send it back out for another 28-day comment period. But that's a fluid process, and it's always going to be different every time, just depending on the issue that you're trying to address, how controversial it is, and how comfortable the board is in implementing the rule. And all that entire process, though, goes hand in hand with the enforcement of those rules. So the more transparent, the more involvement you can allow the membership to have in the process, I think the better off you're going to be in terms of compliance with the rules. And if there is a violation, enforcing those rules is going to be much easier from that standpoint, because once you flushed it out with the membership and the board, and you have drafted a solid rule that is, not going to be subject to ambiguity and interpretation, enforcement is going to be a lot easier.
And one thing worth mentioning, you don't see it a lot, but the members have a right to reverse a rule that the board adopts. And there's a whole procedure behind that we won't get into, but it does kind of raise the point. Don't adopt a rule that everybody's against, because the members actually have a right to reverse the rule. So keep that in mind.
Yeah, it's a good point. It's a good point. Okay, election rules.
Election rules. These are legally required. Associations are actually legally required to have a standalone set of election rules. So we get the question all the time, well, hey, our bylaws address election rules and they're even up to date. We just did them a year ago. They actually address and account for SB 323, for example. Do we still need election rules? The answer is yes, because the law says you're supposed to adopt election rules. But the election rules are kind of where your bylaws might not go into as much detail about the election process and, submitting a candidacy statement and how all of that materializes. That's really a good kind of location where to include all of that. Board qualifications, usually those are contained in the bylaws, but based on SB 323, you can equally set forth your board qualifications in the election rules. So that's a good thing. Procedures regarding the inspector of election is also usually set forth in the election rules. But I think the key takeaway is, they are a standalone document and you are required to adopt election rules, and you should reach out to legal counsel if your association doesn't have election rules, regardless of what's in your bylaws. And if you don't have election rules, that's technically something that a homeowner could use as the basis for a challenge to invalidate any election. So if you don't have election rules and you still do everything the right way, as far as the election process, it is a, whether you call it a technicality or not, it's something that an owner could call out and potentially invalidate an election.
Amenity use rules. I was mentioning this earlier. Fair housing considerations. There's a ton of companies and lawyers out there that are just itching to file a lawsuit against associations regarding discrimination claims. And one of the things they do is they'll go onto the community website and they'll do a word search for children or other potential discriminatory terms that might be used. And if they're able to find one, then you're sort of stuck. And so you want to be proactive about it, making sure in your amenity use rules, meaning that if you have a park or a pool or some other amenity, that your rules are that they don't discriminate, that they are in compliance with the applicable fair housing laws. Another thing is you want to deal with the health and safety aspects of the particular amenity that you're dealing with. If you're dealing with a gym, that's something that you're going to want to get legal counsel involved with, because different gym equipment is going to have different safety aspects, safety requirements. If you're dealing with a pool area where homeowners potentially want to have, if they want to throw an event or a party, dealing with those safety issues, getting indemnification or insurance if that's required, dealing with alcohol issues. There's a whole host of different things that could be potential issues with regard to amenity use and you want to deal with. And same goes with nuisance. Nuisance with respect to amenity use is maybe different than normal nuisance issues that you're dealing with in other aspects of the common area or the community. So, making sure and tailoring those provisions to potential nuisance complaints or nuisance issues that might come up in the amenities.
Okay,
Yeah.
this is a really good question here. Maybe a kind of a key takeaway to kind of get on the track of wrapping everything up here. But should all documents be restated together? They don't necessarily have to be. I can certainly say that in almost all cases, CC&Rs and bylaws are certainly restated together. It's typically the case that if you're restating one of them, there's no reason not to restate both. Financially, it's not as significant to do one versus the other. When you put it all kind of together in a project, it's actually more efficient in the long term. Another thing I'll say is, most associations, if your association's documents are original, and let's say they were adopted in your communities, developed in 1989, for example, the chances are your CC&Rs and bylaws are both from 1989 in that case. So it really makes sense to restate both together. Now, rules, as Brian mentioned earlier, you really want your rules to align with whatever's in the CC&Rs and bylaws. So I think most associations will typically kind of handle the CC&Rs and bylaws first. And then once those are done, they'll go into the rules and make all necessary changes. There might be some exceptions to that. For example, like your election rules, you might, they're required by law, so you need election rules. But especially some of the kind of amenity use rules, those you might wait until after the CC&Rs and bylaws are restated, but it definitely makes sense to do them together. Just watch out, because sometimes one document might have a certain voting requirement, and the CC&Rs might have a 60 or 75% approval requirement, where the bylaws might just have a simple majority requirement. So if you are doing them together, you need to kind of watch out for that. And legal counsel can help with how the ballot should be crafted, and how that should be kind of messaged to the community. So, but the simple answer is essentially that the documents should be restated together. with rules generally to follow. Of course, if there's just something very pressing and really important with only one document versus the other, that might be kind of a unique situation, but consult with legal counsel, but 9 times out of 10, they're going to say you should do it together.
Okay, so the timeline, this is just sort of a an overview of what we're looking at in terms of start to finish, getting from the idea of drafting your potential governing document changes all the way to recording and implementing. The first step is board with legal counsel prepares the proposed amendments, and this could be a fluid process with many changes or very few changes. It just depends on what goals you're trying to accomplish. Um, Once the board's happy with the potential amendment or the potential restatement documents, you set it up for going out for membership approval, and we'll deal with apathy and that type of issue, I think, in the following slides. But second step would be getting membership approval if you're making changes to your CC&Rs and or your bylaws. We talked about earlier, you have a mortgagee approval requirement sometimes. Sometimes you have a city approval or county approval requirement. So you want to make sure that you address that as well. And sometimes in the mortgagee approval, it only applies to qualified mortgagees. So if they have to give notice to the association to be a qualified mortgagee, versus other times they don't. Just depends on what your governing documents say. Once everything is approved, then you submit the CC&Rs for recording, and that's a separate process. Depending on the county that you're recording in, it may be very easy. It may be a little bit more challenging sometimes, or sometimes the clerk that accepts or denies the potential recording could throw up roadblocks and say, well, the notary is not correct, or you should assign this part and not this part. So anyway, this is just a brief timeline, but it kind of gives you an overview of what you're looking at, from
And
start to finish.
and I'll mention that clerks, without disparagement to clerks, they're getting increasingly kind of specific when it comes to what they want to see or what they require. So you really need to make sure that the recording process, you don't take that for granted. You do everything correctly. A couple other kind of tips here. Mortgagee approval. This can be costly. If you have a lot of units, a lot of lots, um, you have to send a letter out to each lender of record or qualified lender of record. Well, how do you do that? You have to obtain the deed of trust, i.e. the mortgage for each property. That costs money to get that from a title company. So there's a lot of costs there. So keep that in mind. And one last thing, once you have a draft and you're ready to go out for a membership vote, sometimes members get blindsided because they don't attend the board meetings. They don't know what's going on throughout the process. So another step you might throw in there, although it's not required by law, is just sending it out to members for their feedback before you even go out to a vote. So keep that step in mind, because I would say, probably at least half of the communities do that to avoid controversy and to kind of promote a more transparent process potentially.
Yeah, good point. Good point. Okay, what about apathy?
Yes, we see apathy a lot, unfortunately. It could either mean, everything's just kind of rosy in your community and there's no problems, so people don't speak up or don't have issues, or there's just apathy. People just don't care. They're not involved, and it can be a burden on progress in the community. So, this is something you need to account for when you're going through a project, a restatement project, or even just kind of a simple amendment, getting out the vote. I mentioned sending out documents before you vote on them. One of the kind of angles there, aspects to that, is holding town hall meetings. We were doing that a lot physically. pre-COVID. Even during COVID, we held a lot of town hall meetings via Zoom, virtually. So, and sometimes that allows for more people to attend. Town hall meetings are not board meetings, a little less formal. They allow for everybody to really just kind of get information, be educated on what's being discussed, and then ask questions. And seeking feedback and campaigning for changes. This document or these documents or the amendments, they're the goal is to do it in the best interest of the community. It's for the homeowners. It's not for some third party company. It's not for management. It's for the homeowners. So when the board proposes something, the board needs as much feedback as possible. And that's why campaigning for changes or kind of seeking that type of feedback is really important. But there are ways to combat apathy. But ultimately, you do have to obtain the approval of the number of members that are required in the document itself. So you have to go based on what the approval percentages are, and you have to meet that.
Yeah, and this is all information that if you have to go to court and get a judge to approve the documents, the judge is going to ask you whether you've done these things anyway. And so you're sort of killing two birds with one stone, because doing this hopefully will increase your chance of actually getting a sufficient number of owners to vote for the document to approve it via the amendment provision in your documents. But if you fall short, it's also going to increase your chances in court, because the judge will look at all of this information and say, well, it looks like they've bent over backwards to give everyone an opportunity to vote, and that they've tried multiple ways of trying to get everyone's vote. And despite all of that, there's still apathy. And so therefore, I think a judge is much more inclined to grant a petition to approve your documents if you've done all of these things first, and you're able to present that in the way of evidence to the court. Okay, other considerations. We have various packages that I alluded to earlier about at Swettles and Gottlieb. But one of the things that we also include in our flat fee packages is election rules, because make sure election rules are up to date before voting on amendments and restatements. Sometimes you'll want to do that first, because if you have an election that's coming up, Cyrus mentioned this earlier, if you try to have an election without election rules, that in and of itself could be a basis to challenge the election based on the current laws. And so, in looking at the timeline and the costs and all the different steps you have to take, the board may decide, well, let's just do the election rules first and then tackle the restatement and other things later. So you'll want to talk to your legal counsel about that option as well, because based on the new laws, that could be a concern. And so you may just want to tackle election rules first, make sure you have those in place before you do any of this. And with that, we thank you for your attention and sticking with us this whole way. You have our information. If you have any questions at all, feel free to give us a call or shoot us an email, or go to our website, and some of the information and some additional information about us and about the firm are on the website. So thank you very much. Any final comments, Cyrus?
Well, just thanks everybody for your attention, and just I'll make one kind of a comment that the restatement process in particular might feel or seem overwhelming because it takes a long time, and you're really kind of upheaving the entirety of what you're used to in a community. And a lot of people are scared of change, and they can't even tell you what they don't like about new documents or what they like about their current documents. People just sometimes can be reticent to change. So education in the community is important. discussing the project in open meetings is important. It really should be a community endeavor, even though the board kind of steers the ship for certainly at the beginning and through a lot of the process. But just keep that in mind, because it can be overwhelming. But with the proper guidance, it shouldn't be. So thanks again, everybody, for your attendance.